Hello again, you guys. How are you? The last time you and I got together, we were talking about Article 2 of the Constitution, which describes the powers of the executive branch, the presidency. Tonight, we're going to move on to Article 3, the judiciary branch. So very quickly, access the Constitution. I recommend you go to your National Archives site, a fantastic source for a lot of things you and I will be talking about. Go there now. I'll wait. Okay, good. Now that you're on the Constitution, scroll down to Article 3. That's what we're talking about this evening. The good news is it's short. This shouldn't take very long if I can talk fast and you can listen and focus. Here we go. Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The Congress has the power to create federal courts, as defined right here, the federal courts that are inferior in jurisdiction to the Supreme Court. One of the first such laws passed by Congress was the Judiciary Act of 1789. In that act, they laid the groundwork for a basic structure that we know today as the federal district courts, of which there are 94 nationwide. These federal district courts have original jurisdiction in most cases involving violation of federal law. Above these district courts, you have the federal courts of appeal, also known as circuit courts. There are 13 of these nationwide. If you live in California, you happen to be in the 9th Circuit Court's jurisdiction. The circuit courts are primarily courts of appeal. They hear cases that are brought to them from decisions made mostly in the district courts. In cases of appeal, the vast majority of the time, these appeals are made by the defendant who was found guilty in the previous case, and now they want to hear their case or have their case heard again on a higher level because they felt that their conviction in the original hearing of the case was in some way illegal, unfair, unjust, so they're appealing to the next level. Now, if a case is appealed to the courts of appeal, they may or may not hear it. And if they render a decision in a case that the defendant doesn't think was fair, legal, constitutional, they again have the right of appeal. If a case is appealed from the courts of appeal at the circuit court level, the next step up is the Supreme Court. The Supreme Court is the end of the line. It is the federal court with the final authority. And interestingly, when the Constitution was first written, its size was not specifically mentioned. In your lifetime and mine, the Supreme Court size has been fixed at 9. That occurred in the 1860s. Since then, there have been times where there have been attempts to change the size of the court. The most noteworthy of these was during the Franklin Roosevelt administration in the 1930s, when he proposed a plan that could, hypothetically, have increased the size of the court to 15 members. In that attempt, FDR was unsuccessful. That change in the size of the court did not occur. But do be advised, the court's size has changed historically, but not since the 1860s. Okay? Keep listening. Now, all right, the judges, both again of the Supreme and inferior courts, shall hold their office during good behavior and shall, at stated times, receive for their services a compensation. They're going to get paid, which shall not be diminished during their continuation of office. So while you're a federal judge, you're going to get paid. And while you're a federal judge, your pay will never be cut. You might get a raise, but it will not be cut. And that's being stated in nominal terms, not real terms. Section 2. The first portion of Section 2, Article 3, is dealing with the jurisdiction of the judicial branch. Think in terms of federal courts, and these are the cases in which federal courts will have jurisdiction. Listen carefully. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. To all cases affecting ambassadors, other public ministers, and consuls. Now, if you're a little confused, an ambassador is the highest representative of a foreign government on our soil. A consul would be another representative of a foreign government on our soil, but at a lower contact level. If you live in Washington, you would find the German embassy in Washington. If you live in Los Angeles, you can find a German consulate in Los Angeles. Not every nation has an ambassador in the United States. That would be confined to those nations that we carry out diplomatic relations with. Not every major city has a consul from every foreign nation. That would depend on a lot of factors, and we will be pursuing that over time. Keep listening. To all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states. So if there's a conflict between California and Oregon, it wouldn't seem logical that you would want to hold the hearing or try the case in one of the state's courts that is represented in that case. So it seems logical that that would appear before the federal courts. Between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, that makes a lot more sense when you look at a map of the United States as it stood in the 1780s. And remember, a lot of these states at that point had claimed territory to the west, far extending far beyond the extension of the boundaries of those states as we recognize them today. All right? And between a state or the citizens thereof and foreign states, citizens or subjects. Now, with the courts, there are two kinds of jurisdiction: original and appellate. Very simply stated, original jurisdiction means that is the first court to hear the case. Appellate jurisdiction means the court is hearing a case that has already been heard by another court, and they are hearing it on appeal. So, here it reads, in cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. So they're the first ones to hear that kind of case. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So remember, a little more flexibility is built into the document here, giving the Congress the latitude to address judicial concerns as they may develop. The last portion of Section 2. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. The only kind of cases on federal charges that don't end up before a jury are impeachment cases. And remember, that can be a president, but it's not just presidents. Federal judges have been impeached, and some have been removed. It's a very small number, but it has happened. In the case of the impeachment, once again, remember, the House of Representatives, in the case of the impeachment of a president, announces the charges. The Senate is responsible for the conduct of the trial and for the vote on conviction or not. There is a trial of President Trump that will occur in January, that shall begin in January 2021. All of this stuff is relevant to what is happening right now. Section 3, Article 3, we're almost done. This is talking about treason. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. This last line is perhaps the most ominous line in the United States Constitution. I have no idea why we don't hear this line quoted more often. Listen carefully. The very ending statement in Article 3, Section 3. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Attainder of treason shall work corruption of blood?